morning. Thank you guys all for having me. It's good to be back. What I am going to do today is I have gone through and kind of kept track of legal issues that have come across my desk and things that real estate agents call about and have had their clients call about the last couple months, and paid attention to what are the most recent types of cases and litigations that have arose. And I'm going to talk about those types of things. And I've tried to focus more on nuts and bolts type issues that real estate agents and brokers have called about, so that I can maybe be more informative and answer questions that you guys have in the day-to-day practice of, that you guys have, as opposed to just talking about non-disclosures and deposit issues and things that you probably already know about. So the four things I'm going to talk about today are partition lawsuits, trees and fences, finder fees, and what a lis pendens is and when you record it. So I'm going to talk about that for about 45 minutes and take, if you guys have questions about the things that I'm talking about as we go through, feel free to ask questions. And then at the end, I'll leave 15, 20 minutes and you can ask whatever you want. And if you guys have, questions about, the typical non-disclosures or fraud or boundary disputes or those types of things, I'll answer whatever you want. And, we can go whatever direction you want the last 15, 20 minutes. But the first thing I want to talk about are partition actions. And what a partition action is it's the default remedy when two or more people own a piece of property and one of them wants to sell it, and the other owner or owners do not want to sell it, and they can't reach an agreement. So if there's no agreement as to what to do with the property, the default remedy is one of the owner that wants to sell the property can file a lawsuit in court, which is called a partition lawsuit, to force the sale of the property, and the court will order the sale of it. Now, one of the reasons I'm talking about this is because anytime there is a downturn in the real estate market, the number of partition lawsuits dramatically increases, because one of the owners inevitably has equity in the property that they need to get out of it, and other owners in the property want to hold on to it, right? So if you got three owners of a property, or let's say you got two owners of a property, inevitably what happens is one of those owners says, well, let's ride out the market, right? Right now the price is depressed. Let's ride it out and wait a couple of years till the market comes back. And another one of the owners says, no, I need to get my money out. Let's sell it right now, regardless of what the property's worth. And the owner that wants to sell can file a lawsuit and force the sale of the property. Now, a partition action applies regardless of how owners hold title, whether they hold title as tenants in common or joint tenants, right? Regardless, either way, one of the owners can file a lawsuit and force the sale. And it arises in a variety of situations. It can be heirs that inherit the property, whether it's brothers and sisters or cousins or whoever inherits it from their parents or family members. It can be friends that bought property together. It can be an unmarried couple, boyfriend and girlfriend, that buy a property together and then later split up. It can be spouses that divorced but decided we're going to continue to own the property even after the divorce. It can be business partners, joint ventures that decided to buy the property and hold it for a period of time, right? So there's a different number of situations where people can hold property together and then later on have a dispute as to what they want to do with it. Now, prior to 2020, which I'll refer to as the old law, this is how things transpired if somebody wanted to file a partition action. It was incredibly cumbersome. You filed the lawsuit, and if the parties did not agree as to what happened, this is how the lawsuit went. The party that filed the lawsuit first had to file a motion to get a broker appointed. And if they didn't agree, each side could nominate 5 brokers to the court, and the court would then pick one of the 10 brokers that was appointed, and the court would appoint the broker. Then if they didn't agree as to what happened to the property next, right, the broker would have to go to court to get approval to list it for sale. Then when all the offers would come in, if they couldn't agree as to which offer got accepted, they would have to go back to court to get approval for the court as to which offer would be accepted. Then when it came time to sign off, The court would have to go back to the court to get an order for the clerk of the court to sign the offer. And then in escrow, they'd have to go back to the clerk to sign all the paperwork to sign off. Now, as you can imagine, that not only takes months each time you have to go back to court, right? But you have to find a buyer that's willing to wait 4, 6, 9 months to close escrow. Now, when we're in law school, when the professor would describe a sale of property, they would describe it as a bundle of sticks. I don't know if you guys have ever heard this analogy, right? But that when you have the entire market of people willing to buy, you have this big bundle of sticks. And every time you add a restriction or you add an encumbrance or you add a limitation to the sale of the property, you're taking away a number of sticks out of the bundle, right? And in a partition sale, you take out a big bundle of those sticks when you're taking out all of the buyers that are not willing to wait 6 or 9 months to buy the property, right? So when you have in a partition sale is you only have the buyers that are willing to buy a property that is going through litigation, that is going to take this number of months and this number of steps to go through it. And what happens is you end up with a far limited number of buyers willing to buy, which means usually you end up with a price that is far less than the fair market value of the property. So, and the other problem that you end up with is you end up with the parties incurring a tremendous amount of legal fees that go through this process. So not only are you paying real estate commissions and closing costs, each side is paying much more in legal fees to get through the sale. So in 2021, the legislature enacted what was called the Partition of Real Property Act. And it was designed to address a very specific type of problem to make partition actions go faster. And I'll describe the specific problem first. As maybe you've heard, one of the biggest areas of the practice of law that's growing the most is estate litigation. With the baby boomer generation starting to pass away, there's a lot of litigation and probate that is happening where the property of the baby boomer generation is passing now down to the next generation. And as it's passing down through inheritances, it's becoming very complicated from a litigation perspective. And I'll give you one specific case that I have that exemplifies this well. 2 parents transferred their property down passed their property down to their 9 children. Okay. While it was in probate, you use the term children, right? But realize that the parents, when the mom finally passed away, she was 101. So their children were ages like in the 70s to their 60s. Okay. So while it was in probate, one of their children passed away. So that 1/9 share went to her 3 kids, who then inherited 1/27 each. Okay. But she died without a will. So that had to go through through probate and was intestate. Okay. She then had 4 kids who each were going to inherit 1/111th of the property. Okay. One of those kids, and each 111th of the property was worth like $36,000. Okay. One of those kids wanted to cash out and just take his share early. So sold his interest for $20,000 cash, right? The person who inherited that 1/111th filed a partition action to force the sale of the property even before he had a grant deed that said he actually owned it, right? More commonly, what was happening was, prior to 2020, what was happening is family members would inherit these random fractional interests, right? I have, 2.7% of this property that I inherited from my great grandmother, right? And they would sell it to somebody, some person outside the family. That outsider would then file a partition action and force the sale of the property, right? And as I explained, when you force the sale of these properties, the idea from the outsider was to force an auction sale that would be below market value so that they can then buy the property below market value from the family, right? It's almost like forcing a foreclosure against a family. So the goal of this revised partition statute was to give family members a way to buy out these outsiders without having to go through this long, expensive process. Okay. So the new partition statute, what it does is it says, if you inherited as by an heir, if you're an heir that inherited, if it applied to anything that was less than 20%. If you had an heir interest of 20% or more, then this statute applied to you, and you could force this outsider to sell his or her interest through an appraisal mechanism. You could force the property to be appraised, and the person that wanted to be bought out by partition, right? You could force their interest to be sold through an appraisal process through the court. So I'll take that same example where the outsider acquires a 2% interest. And let's just say the property's worth $1 million. They file the lawsuit. Instead of having a broker appointed right away, you just go to court and say, we want an appraiser appointed. You have the appraiser appointed. The appraisal comes in at $1 million. The court says, great. The plaintiff who filed the lawsuit, your 2% interest is worth $20,000. Do any of the other co-owners want to buy this person out for $20,000? If they do, you write them a check, you acquire his interest, the lawsuit's over. So it was a much more expedient, efficient way to acquire that person's interest. If none of the co-owners want to buy that person's interest, then it goes back to the same process of a broker is appointed, then the property is sold. Yes. So hold on. Where'd Jody go? Oh.
Can you hear me? Okay. Okay. You mentioned it have to be 20% or more.
Yes.
In order for them to fight back from the outsider. But what if you only have 20% or less?
So the way the statute is written is it defines an heirs property, close quote, where 20% of the interests are held by relatives or individuals who acquired it from a relative. So the triggering statute is what it means is at least 20% of the ownership needs to be held by family members. Right.
Yes. Yeah. First, good to see you back.
Thank you.
It's been a while. I'm still a little confused about it. I mean, I understand the concept. What if the house doesn't have to say you have a trust, and the trust doesn't specifically say that house. It says there's a house, there's loan money, whatever. Does that change the whole thing here? Or is it specifically before you can do this partition act, does it have to say the house this is what the portion of the house itself is? So I don't know if that makes sense. They don't have to separate the assets, or they can.
No, so the statute would apply after it comes out of the trust, right? So it would be like, so you have like parents have a trust.
Yeah.
And the trust says the property is going to go to these 9 children, right? So then you do the trust administration, and the trust gives the property and actually transfers it to the 9 children. Now the 9 children own it. A, B, C, D, E, F, G.
Yeah.
Right. Then one of those 9 children, right now there's 9 co-owners. One of those 9 co-owners sells it to me. Right. So I own now a 1/9 interest with 8 other siblings, and I go file a partition action.
So this is only if the home is pulled out of the trust, given to the 9. I mean, all 9 of those people are holding title to that property. Right. But if it's in the trust, and it's still in the trust, this won't happen. Is that correct?
Right.
Okay.
Right. This only applies after trust administration.
Okay. And it's 20% or more before it applies?
It applies if the heirs own at least 20% of the property
The heirs as a group.
as a group.
Okay, thanks.
All right. So this is an example of where a statute actually worked. So the initial statute that applied to just heirs, and that was enacted in 2021. In 2023, this year, the statute was expanded to apply to any partition action owned by tenants in common. So the legislature realized that the statute was working and essentially expanded it to almost any partition action, because almost most properties are held as tenants in common. So at this point, there's very few cases where it doesn't apply. The benefits of it are now that, the partition actions under the old law that were slow and cumbersome and expensive have basically been made obsolete. And most partition actions now can at least the co-owners have an option to try to buy out the plaintiff that filed the lawsuit by an appraisal process. The main so from a real estate agent perspective, what are the reasons that you need to know this? Okay. The first thing that's important is there are a lot of real estate agents that do these types of lawsuits where they go get appointed by the court and work as partition agents, right? So if you do that type of work, right, you need to understand the process of being appointed by the court, and that once you're appointed by the court, you are the fiduciary for all of the parties. Even though they're adverse to each other, they're all still your clients. So you still are fiduciaries to all of them and need to work for all of them. The second thing, if you do this type of work, is you need to understand that the court order that appoints you supersedes the contract. And this sometimes gives rise to litigation, because a lot of times the court issues an order that says these are the terms of the sale of the property. For instance, the contract is to be non-contingent. And then the real estate agent goes and accepts an offer, advises the clients to accept an offer with contingencies. Then the buyer cancels the contract because the contract had a contingency in it. And now there's a deposit fight because there's a court order that says it was non-contingent and a contract that says it was contingent, right? And then they go back to court to settle the deposit dispute. And the judge says, I don't care what your contract says. I issued an order that said it's to be non-contingent, right? And the parties look at the real estate agent and go, this is your fault. What else did I want to talk about here?
We got a question on Zoom. I'm
Okay.
over here. Who pays the legal fees for the appraisal process for less than 20% interest per person? What if no one buys it and then it goes to the court process?
Okay, so the answer to the first question is the legal fees are paid by the parties. So the plaintiff that filed the partition action and the co-owners all have to pay their own legal fees. And the appraisal is usually split equally between the parties. And that's usually by court order. So usually the court will order that the parties split the appraisal process, or sometimes each party may get their own appraisal if there's a dispute. And what was the last part of that question? If it goes, there was something about.
What if nobody
goes,
buys it and it goes through the court process?
So if none of the co-owners buy the property, then it just goes back essentially to the old process, which means the broker lists it on the market, and it goes to open bidding to any buyer can buy it. Goes back to sale. This is like, let's make a deal.
I apologize. I'm still trying to get my head on this thing. So hang on there for a minute. This particular, yeah, Grace, I love you too. let's go back to this example, these 9 beneficiaries. Why wasn't this property sold from the trust? I mean, why did they why was it transferred to these 9? But it seems like this was handled badly. That wasn't you, was it?
Well, no, and so the case example that I have was not a trust.
Okay,
It was the parents deeded the property to the 9.
so there's no trust involved
There
here.
was no trust involved.
Okay, that's
What about a partition action? You talked about tenants in common, joint tenancy, what about if the property is in a general partnership or corporation? Can they also ask for a partition action?
Yes, but there would have to be two corporations, right? For a partition action, there has to be at least 2 different owners. So if you had a joint venture that had 2 LLCs that different owned it, right? If my LLC and your LLC owned it together, my LLC could file a partition action.
But you're only one LLC. You can't.
Correct. Hold on, I got to get the mic ran over to you.
Good morning. What's the average time frame for a partition action?
The average time for a partition action. Well, I have to divide the world into pre-COVID and post-COVID. So prior to COVID, when the legal system functioned, I would say 9 to 12 months. In the post-COVID world, where we don't have any judges, bailiffs, or clerks, I would say 2 years, maybe. Santa Clara County is a well-functioning county from a legal system perspective. When you file a lawsuit, your first hearing is in about 8 months. And that's the hearing where you show up and the judge goes, so what's this case about? When you file in Alameda or San Francisco, you get a letter that says basically the court is backlogged, expect a trial date in 5 years. Right. By the way, there's a state law that says you have to have a trial date in 5 years or your case gets dismissed. So it is difficult right now, let's say.
So if we come across these families that might be in this situation, what's the best advice that we can give them to help settle among themselves? Obviously to see you, but coming from us.
So there's 2 parts to that, right? The general advice as to a real estate agent is to use a lawyer as a shield, right? Because you never want to be accused of practicing law, right? So the simple advice is to tell them to see a lawyer to clear up the title to the property, right? But the practical advice is that it is better for them to work with their co-owners to figure out a solution to sell the property as opposed to filing a lawsuit, right? I'll just give you a simple example, right? A lot of times boyfriend, girlfriend come into my office, one of them comes in, the boyfriend comes in and says, I want to sell the property. My girlfriend doesn't want to sell the property. Well, why doesn't she want to sell the property? Well, because she thinks I owe her $20,000, right? I will often, after letting him vent for 30 minutes, explain to him that the best he can do is pay off that $20,000 because that is much cheaper than spending legal fees and selling your house for $200,000 less in a partition case, right? No, because I would have a conflict of interest, right? I mean, so once people are adverse to each other, right, I can only represent one of those people.
Over here again. Anthony, listen, let me ask you, what is the background need? If you want to become a partition agent, What kind of background do you have to have? I mean, just if you have a license in California as an agent, that's all you need. What kind of experience? How does someone become a partition agent, I guess?
There's no specialty that you need to do it. You know, you need to be, you know, you should be familiar with the legal process and understand what you need court approval from. But I mean, that's not anything you can't learn, you know, by just researching. And the lawyers in the case are going to essentially spoon feed you for what you're going to need to do. Because you're not going to be able to, you're going to have to go step by step. Right. So for instance, if Grace is my client and she wants you to be right. And she wants you to be the agent, right? I'm going to walk you through what I need you to do. Right. So we're going to nominate you to the court as our agent. And if the court appoints you, or if the other side agrees to you, right, then I'm going to walk you through everything you need to do. Right. The lawyer's not going to set you up to fail.
So how do you connect with the lawyer? I mean, it goes back to the basics. Do I start dealing with, I mean, what lawyers do we need to talk to? How do you develop that relationship?
So it's usually estate litigation attorneys are the ones you market to. And I get real estate agents that market to me all the time for this stuff.
His wife's a realtor, so. A good one, too.
But normally, like all the probate and wills and trusts and estate attorneys, right? I mean, they're the ones who, because they also, not only through partition cases, but they're the ones who, when they have like even just trust administration, right? They're the ones who just have to sell properties out of trust all the time, even though it's not through litigation. They still have that same type of work.
Now, if your wife wasn't an agent, how would you decide which person to bring in? How do you develop a relationship with these agents? I mean, is something from his past experience? I mean, how would an agent create that connection, I guess?
So I guess I'm a little bit different because I do a lot of this marketing stuff. I'm around real estate agents all of the time, right? And generally speaking, I try to reciprocate with people that refer me work, right? And also, so if I'm going to refer somebody out, right, I try to refer out always 3 people. As opposed to just one person, so it doesn't, look like I'm trying, there's
Scary.
right.
Well, you can steer me like
But I mean, I think for the most part, you're just trying to convince a real estate attorney that you're a good agent and you know the area and that you could take care of their client.
Thank you.
All right, I think that's it on that. We good? All right. Next thing I want to talk about are fences and trees. Now, I don't know what happened during COVID. I don't know if it was because people got trapped in their houses and everybody, started fixating on their boundary lines, but I've been doing this over 25 years. And the first 22 years, I think I got about 1 fence and tree case a year. And then COVID hit. And I swear to God, I get 5 calls a week about, can I cut down somebody's tree? Can I cut down somebody's fence? Can I call the police if somebody touches my fence? The amount of attention the last 3 years people spend on their boundary lines has increased dramatically. And I get just as many calls from real estate agents in the middle of deals asking about these questions. So I'm going to spend 10 minutes giving you the basic law on boundary lines and trees and fences so that you just understand it and you can answer the simplest of questions for people. Okay. So I'll start with fences, right? When fences are on the property line, okay, I'm going to make the distinction between on the property line and off the property line. Okay, when fences are on the property line, then they are co-owned. Each side equally owns the fence, and each owner has an equal obligation to maintain the fence. if the fence is exclusively on one person's side, right? So it's on my land, then it is my fence. And I can do anything I want with that fence as long as I comply with whatever other rules exist by the city, county, or if there's an HOA and HOA. So for instance, the city may have a setback rule that says the fence has to be within a certain amount of feet of the property line, or it has to be, can only be a certain height, or can only be a certain material. Or the, if it's on a riverbed, sometimes the city says it has to be, has to be a certain material, has to be able to be seen. You have to be able to see through it. Or an HOA may have specific rules about what the fence has to be or cannot be. Okay. The definition of on my side is 1 millimeter or more. Okay. The property line is a razor thin line that goes to the core of the earth and to heaven. And if you're inside that line, it's your property. And if you're on that line, right, then it's a common fence. So people call and say, right, I want this type of fence and my neighbor doesn't want to do it. Can I build it? And the answer is, if you're willing to pay 100% of the fence and you're willing to put it 1 inch inside the property line, then you can make that your fence and you can build what you want as long as you comply with whatever the city or county code is. Right? Now, there's also something called the Good Neighbor Fence Act, which is in the Civil Code, Civil Code Section 841. Yeah, 841. Which this is the code you want to comply with if you want your neighbor to pay 50% of the fence. And the Good Neighbor Fence Act says you need to give 30 days written notice to your neighbor. And you need to essentially tell your neighbor what's wrong with the current fence, what you want to build, and when you want to build it. Right? Usually that means you give the neighbor a copy of the written bid and that shows what's going to be built and what the cost is. And if you want your neighbor to pay half, the limitation is you have to be proposing a reasonable fence. And in our area, a reasonable fence is usually defined as a 5 or 6 foot wood fence. Right? You can't propose a wrought iron, $60,000, iron fence that, ornamental iron fence. Where the fights start to occur, okay, where we start to get subjective, and the storms did a wonder on this, okay? You have a 20-year-old fence that seems perfectly fine to one neighbor. And to the other neighbor, that is a horribly old fence that obviously needs to be replaced. Right? And one neighbor says, it's got to come down. And the other neighbor says it's completely fine. And the neighbor that thinks it's fine comes home from vacation and the fence has been torn down. Right? And the neighbor that tore it down says, well, obviously now we need a new fence and you need to pay for half. Right? Another example is, the neighbor on, let's say the neighbor on the left gives the 30-day good neighbor notice that says on August 1st, I'm going to tear down the fence and build the new fence. And the neighbor on the right does nothing, doesn't say anything about it. And then on August 1st, the neighbor on the left thinks, okay, the neighbor on my neighbor must obviously be okay with it because he hasn't said anything. And then on August 1st, the fence company comes and the neighbor on the right calls the police. Right? And the fence guy is out there in the middle of doing the work and the police come. And then the neighbor on the right comes out and starts screaming, you destroyed the fence. I'm going to sue you. I'm going to have you arrested. And it's the Hatfield and McCoys in the middle of the yard. Right? And these are the types of things that are happening. Right? So what do you do? there's options from most, from least aggressive to most aggressive. And these are kind of what they are when people can't work it out, right? One option is you can have a survey done to figure out where the property line is, because one of the big disputes is always, is the fence on the property line or not? In an old city like San Jose and our surrounding areas, you'd be surprised the number of times the fence is not actually on the property line. And this is another one of the areas we see lots of disputes. Is what happens is, neighbor A buys a house and is doing remodeling or doing an expansion, and for whatever reason does a survey on their house and finds out that the fence isn't on the property line, and writes a letter to the neighbor and says, hey, I found out the fence isn't on the property line, and it almost always seems that the fence is inside neighbor A's side and they want to push it out into neighbor B's property. So they write neighbor B or to go knock on neighbor B's door and say, hey, the fence is a foot into my yard. I want to move it over to the property line. I need to push it into your yard. And neighbor B says, no, I don't agree. The fence has been there for 10 years, 20 years, 40 years, whatever the case may be. And now there's a dispute, right? And sometimes neighbor A just lets it go. Sometimes neighbor A gets a lawyer and says, we're going to, file suit to move the fence. Sometimes neighbor B just rips the fence down and decides we're going to start building, and just, waits to see what neighbor B does. And in those instances, what now neighbor B is forced to do what? Their options are they can go get an injunction to stop the building of the fence. They can let it go and decide it's not worth fighting about, or they can file a lawsuit for destruction of the fence. And those are their options, right? Getting back. So what, the options are, if you don't, if you're the person who's the fence is encroaching onto their land, you can get a survey done ahead of time to try to convince your neighbor that the fence is in the wrong location. If you're the neighbor that gets the letter that says the fence is in the wrong spot, you can go get your own survey to see where the fence, where the fence is located vis-a-vis the property line and make a determination. The other issue that inevitably comes up is, even if the fence is in the wrong location, the next question is, well, does neighbor B have an easement based upon where the fence has been for a period of time? Do they have a prescriptive easement? Do they have an equitable easement? Do they have what's called an easement by subdivision because of how the properties were created when the lots were divided? And it's also, based upon what is in that strip of land, right? I mean, just taking the simple example, if the property line's off by a foot, it often matters is in that 1 foot strip of land, is it just dirt? Is it concrete? Is it the equipment for the swimming pool? Is it something that is moving the fence very simple, or would moving the fence, entail, spending $20,000, $30,000, $40,000 to move something that's in that 1 foot? Sometimes, I have a case right now that's in Campbell where 20 years ago, it's a small old house, and 20 years ago, the previous owner applied to expand the rear of the house, and they got a survey done. And based upon the survey, they got a permit to expand the back of the house to 5 feet within the setback of the fence. So now, if you look at it, the way the house was expanded, it goes to 5 feet within the back of the fence because that's the maximum allowed by the setback. Well, it turns out the surveyor was wrong, and the fence was in the wrong spot. And the house itself, the fence is 7 feet into the neighbor's yard, and the house is 6 inches into the neighbor's yard. Right? Well, the neighbor's house went into foreclosure. A developer bought it out of foreclosure. The developer then did their own survey because they want to now knock down the house and build a lot, build a house on the lot, right? And they essentially can't build a house because they can't go to the property line because there's a fence that's several feet into their property, right? And it's one of those long, narrow lots, right? So the house that they would be allowed to build, if they have to build within 5 feet of the fence that encroaches with them, right? Like they can't build what they want. So they've sued, they filed a lawsuit, right? That's essentially like move your fence. And, you know, the question is like, do they also have to, does my client also have to move their house? Right? Like, do they have to rip out the addition, right? And the question is, well, it's like, wait a second, the addition was permitted by the city, right? So, I mean, so these boundary type issues can get very confusing very simply. But getting back to the simple fence issue that I started with, lots of people are having these questions. Lots of people are becoming very territorial, and we're seeing it very often come up during escrow. That during escrow, buyers are asking questions about where is the property line? Is the fence on the property line? Neighbors. Another thing we're seeing very often is neighbors are writing letters to to listing agents, right? That we're seeing neighbors write letters to listing agents that I want you to know, dear listing agent, I want you to know the fence encroaches onto my property and I expect the new buyer, whoever it is, to move the fence, right? So from an agent's perspective, what do you need to be aware of, right? I think the first thing is, I think you need to be acutely aware of at least red flag issues that if a lawsuit is ever filed, you need to be aware of things that common sense would have told you in hindsight. For instance, when you're doing your property inspection, just be aware of what the fence lines look like. Stand on the curb and look back, especially on, houses in regular subdivisions, right? Are the fence lines straight? We've had cases where there's nothing noted in the disclosures, but then you go out there and the fence lines have these jagged, look like lightning bolts in them. And it's like, nobody said anything about that. And it's like, yeah, I mean, as a lawyer, we play Monday morning quarterback and we're coming in after the fact, but it's like, sometimes it's like, really? No, nobody? Like that's 5 feet in and then 5 feet back out. So just be aware of certain things like if then we go back and we look at the grant deed, and the grant deed says 70 feet by 80 feet by 70 feet by 80 feet. It's like the grant deed describes a perfect rectangle and the fence line doesn't mirror that at all. And no one said anything about it. Right. So I'll get you 1 second. So just kind of take a visual observation of are the lines straight, or if they're supposed to be straight, or are there any physical impediments, right? That the fence lines are going around. We have a question in the back with the mic.
One on Zoom real quick.
Okay, then
I've been waiting.
We got the mic back there after.
Yep. What if the fence is shared with the city property and or an apartment complex?
Okay. So if the fence is shared with either a city property or a apartment complex, I'm assuming the question means that it's on the property line. So it's a common fence that they both own it. That would still mean the city or the apartment owner still has 50-50 maintenance obligations. The interesting tidbit there is with the apartment owner, if the fence is off the property line, you still have that issue of there may or may not be an easement with the apartment owner as a private owner. So if it's off the property line or encroaches, there may be easement issues there. You cannot acquire an easement against a government entity. So vis-a-vis the city, if it turns out your fence encroaches the fence encroaches onto the city property, say by 3 feet into the city property, and the city comes to you and says, we're pushing the fence 3 feet into your property onto the property line. And you try to the city say, well, wait a second, the fence has been there. I have an easement. You can't acquire an easement against a government entity. So the city would have a much stronger claim against you to push that fence into your property.
I'm walking over. I also want to remind people that if you have clients that are taking videos of their neighbors doing things or are posting those videos on social media or on Nextdoor, I think, Tony, you said this last time, tell them to stop it. Because we're not going for likes and views on TikTok. And I think, Tony, you said last time that could end them in some very legal hot water that has nothing to do with the fence anymore.
Yes.
Hi, Tony.
How are you?
Good. So going back to the case you shared where the buyer is buying the property and the property he's buying is encroaching into the neighbor's property, and the neighbor wants it to be moved back. Now, the neighbor who's bought this property at the time of purchase also has the responsibility to investigate. Now, if he has not investigated and didn't know that and didn't do his due diligence, does he still have a right to claim?
Yes, because so the buyer has two different issues, right? The buyer may potentially have a non-disclosure claim against the seller, right? Whether the seller disclosed that to the buyer. And that could be time barred, or he may or may not have a claim because it may have been disclosed or may not have been disclosed, or he may have waited too long to bring it. But that's one claim, right? Did the seller to the buyer disclose that issue? But the issue of an encroachment between the two neighbors always exists. And so an encroachment occurs every single day, right? So if you and I are neighbors and you're encroaching onto my property, right? That's happening every day. Every day you're encroaching onto my property, and every day is a new tort. So every day I have a right to bring that claim against you. And at some point, you establish an easement against me, and you end my right to bring that claim because now you've established this easement, and you can go to court and perfect your legal interest on my property, right? And that would be the lawsuit, right? I would say you're encroaching, and you would say, no, I have an easement, and a judge would determine who is right. But between two neighbors, that fight continues to exist until a judge decides it.
Hi, Tony. I have actually two questions I think deserve quick answer. I know you can do it. Regarding the easement,
I like your confidence.
because I'm sure Jody will allow me to ask two questions. Regarding the easement, how many years will it take to establish the easement between residential properties? And the second question is, how many feet will be the setback in Santa Clara County? And now with the ADU, I think they have narrowed the setback, correct? Is that correct? Thank you.
I'm gonna let you down dramatically. The second question, I do not know the answer to, because the cities have different setbacks for different properties and different locations. So for instance, like San Jose has a 5-foot setback on the side, right? But maybe 10 feet from the rear. But if you're a corner property, right, there's different setbacks. So anytime you're asking a setback question, it's property specific that you need to always go double check. The length of time varies. So there's one specific type of easement called a prescriptive easement, which is what people think of the most. That's when you are actively using someone's property on purpose, and that is 5 years. But there are other types of easements where there's no specific time limit. So for instance, an equitable easement, the judge has discretion. So there's no specific minimum or maximum amount of time it needs to occur. Setbacks, you check with the city or county, whoever has jurisdiction. Oh,
I have the
one behind
mic.
you.
5 years, is that if if it exists for 10 years and then it becomes apparent, then that's when the 5 year begins, correct?
The 5 years begins when you start taking the use.
Or when people become aware.
No, it's when you start doing it.
Oh, well, what if no one was aware the fence was on the other side until a point 20 years later? And then someone said, oh, well, it's been there 20 years, but no one knew it was there.
So one of the elements of a prescriptive easement is it has to be open, notorious, and hostile. So by definition, in order to acquire it that way, you would have to be aware from the minute you start doing it.
So it would be prescriptive after 20 years because you're not aware it exists.
If you're not so
Right.
let me do it a different way. Okay. Prescriptive easement started in the old days when we were settling the West. So I have 1,000 acres of land, right? And in California, but I live in Missouri, right? And I'm not paying any attention to my land in California. And you and your family you set up a house and you take 10 of my acres, right? And you're living there, right? You are openly, adversely, and hostilely using my land, right? The fact that and you do it for 5 years, right? Once you do that, right, you've acquired title to my land. That's called adverse possession. Okay. That's how you acquire title to somebody's land. And you do that for 5 years, you get title. Prescriptive easement is a corollary to that, where instead of acquiring title, you acquire the use to my land, right? So if you were using my land as a driveway to get to your 10 acres, right, you would get an easement across my land to get to your 10 acres. And if you did that for 5 years, you would acquire that easement. The fact that I'm an absentee owner and not aware of it doesn't matter to the court. That's my punishment for not paying attention to my land, right? So it's when you use the phrase who's aware of it, as long as the user is aware of it, that's all that matters. As long as you do it for 5 years, that's what matters. Go ahead.
My question was more about the Good Neighbor Fence Act.
All right.
So I listed a home and the fence between him and his neighbor was fallen down. It was completely down. And they had a pool and a dog, the other neighbor. But I put a letter in their post or whatever, and they just didn't answer it. Is there more of a case for him if there is like an empty pool or a pool and a dog? What's the recourse if they just don't want to do it?
So the Good Neighbor Fence Act, all that helps an owner with is making the neighbor pay 50%.
And if they don't want to, there's really no recourse, because honestly, it's cheaper probably for the owner to do it himself than to get an attorney.
Right. So if all you want to do is build the fence and you're willing to pay for it, you can do it the same day.
Okay.
Right. The Good Neighbor Fence Act is just 30 days written notice if you want to make the other person pay 50%.
Got it. Okay, perfect.
Right. The remedy is you can sue them in small claims court.
And we got a Zoom question and then we'll come to Mark. If the neighbor sends the listing agent a letter demanding new prospective buyer to pay to remedy the fence, would the listing agent be able to request from that neighbor to provide the results of a survey that shows their contention?
The answer to the question is yes, but I would more recommend that the agent just disclose the letter as opposed to get involved in the fight.
Okay, can carry that thought a little bit more. Let's say I'm the listing agent. I get this house into contract for 5 days before close. The neighbor they don't like each other. The neighbor next door writes me this letter saying, hey, this house is on my property. Their fence is on my property. Obviously, as an agent, I have to disclose that right away, correct?
Right.
That person on the other end has a right to cancel the contract. They do. It's material fact on the property. Deals canceled. Would we have a remedy against, if it turns out to not be true, can we go back and sue the neighbor for saying that?
Probably.
Okay, that's a good answer.
Yeah, I mean, probably, I mean, you'd have to, I mean, it would come in. You would have to probably prove that the neighbor knew he was wrong. Right? If the neighbor had a good faith belief that they were right, because the question is, what's the tort?
Yeah.
Right? So if the neighbor had a good faith, like, so let's say, for instance, the neighbor had a survey that showed the fence encroached. And the survey turned out to be wrong, but the neighbor was relying on a survey, right? I'm not sure the neighbor committed a tort.
Well, so they didn't do the survey. They just, hey, I know for a fact, that's what they might say, that's on my property.
Right, well,
And
then-
you tell the buyer that
Right.
before they buy it.
Because then you'd have a tort.
You have a case against them then.
Right.
Okay, thank you.
All right. I'm hopelessly behind at this point. It's all right. I'm going to do trees really quick. They're very similar to fences. If a tree is exclusively on one person's property, that person owns the tree. Okay. You determine who owns a tree by where the trunk is located. Okay. If the trunk is on the property line, then both people own the tree, and both people then are equally responsible to maintain it. If any portion of the trunk is on the property line, both people own it. So for me to own the tree, the entire trunk has to be on my property. If any portion of the trunk is on my property, is on the property line, then me and the other person equally own the tree, and we equally have to maintain it. If I own the tree and the trunk is on my property and the limbs overhang a neighbor's property, okay, the neighbor is allowed to trim what overhangs the property so long as the trimming doesn't damage the health of the tree. You can take whatever overhangs as long as you don't damage the health of the tree. Okay. The roots are a different story. If the roots cross over the property line, you can only cut the roots if the roots are causing property damage. So you can't saw cut the roots just because they annoy you. The roots have to actually cause damage. Okay. At $600 an hour, I actually answer these questions on a weekly basis. People actually call me, wondering if they can cut roots to a tree that do not cause property damage. I'll even give you tripping. Like I'll even say that's a damage, right? But usually what they mean is like it's lifting up your patio, it's destroying other plants, it's pushing on your swimming pool, right? It's doing something other than I don't like my neighbor, so I'm going to cut the roots to his tree so I can kill his tree, right? Or I'm going to put a poison spike into the root because I see it 1 inch across the property line, which are questions that I have entertained.
What if you have a beautiful oak tree that overhangs to the guy's side? Again, the neighbor's a jerk next door. One day he just gets up and just cuts it, say half the tree on his side. Now you've got rid of the look and feel. The oak tree has value of some sort. Can you go back and sue for?
Yes. So yes, and that is an actual case I have. Yes, you can sue, and that is an actual case I have. If it affects the health of the tree, right?
Sometimes you don't know if it's going to affect the health of the tree for years.
Right. And sometimes the tree collapses the afternoon you cut the limb off of it. Right.
Just to clarify, if the roots destroy the property, is the owner of the tree liable for the damage of the other person's property?
Yes. You are liable for the damage your tree causes. Hold on.
And so my question is on the trees that the city require for you to have, and they're on on the other side of the sidewalk, and they're damaging the blocks of concrete that on the sidewalk. And I'm asking you this because last night I was walking and it was around 9:30, so I couldn't see. And I've tripped on this a few times. I can't remember. I mean, I cannot remember every single area that, the pavement is up. And I had a case where I tripped and fall, and I have a scar here, and I ended up in the hospital. The doctor said, if this was here, you'd be dead. So what about cases like this?
That I don't know. Only because I don't know who owns the sidewalk. I think it's the property owner. Yeah, I think you'd have a premises liability claim against the homeowner. Yeah. Yeah, I think that's right. I think you'd have a claim against the property owner.
Hi, Tony. My question is, if the trunk is on the neighbor's land, but is very, very close to your property, and you just mentioned that you can trim the overhang to your property, but does that need to give the notice to the person that owned the tree before, or you can just go ahead, trim it?
So legally, you can just trim it, right? I would highly recommend you give them notice because that's how fights start. But I mean, legally, you can just trim it as long as you don't harm the tree, right?
But-
And then there's also, like you mentioned, there's like oak trees that are protected, right? So certain trees, like, you need to worry that like oak trees. So like another example of a case I have is like oak trees really need an arborist to trim them because you can over trim an oak tree very easily and kill it. And if you have an unlicensed person trim an oak tree, you can damage it and kill it. So for the most part, there's a lot of special trees that you should really only have arborists trim, because if you're the one who kills the oak tree, I mean, I had a case where somebody killed an oak tree and they ended up paying $100,000 in damages for it.
Wow. There's a question about who owns sidewalks. Does the city own the sidewalk or do you own the sidewalk?
My understanding is you own the sidewalk. My understanding is it's a very unfair world where the city can make you keep the tree and make you fix the sidewalk.
So if it's your sidewalk, can you dig it up and put bricks if you want on your section of it? I mean, I'm playing devil's advocate,
No,
I guess.
It's an unfair world where the city gets to make you do stuff you don't like.
And my turn.
Yes.
Regarding the trees on the sidewalk, I think years ago, the city would trim them, but during, I think due to lack of money actually. So the homeowners now are responsible. But I think if the homeowners were to trim it, the one that, I mean, we need permit, right? Because
This is beyond me.
Oh, okay. Because I do see there are people who are trimming it themselves. I mean, it doesn't matter to me.
Is there a question coming?
But some neighbors.
I know Tony's super behind and has to leave in about 10 minutes.
And you'll get fined. Is that true?
Yes.
All right, who'd have thought trees and fences would be
I
so
know that.
fascinating?
All right, I'm gonna do the last two things in 3 minutes, and just so that I can leave some time for questions on other subjects. Okay, finder's fees are things real estate agents are getting in trouble for. A finder's fee is paying an unlicensed person a portion of your commission for finding you a buyer or a seller. Okay, finder's fees are allowed in California if certain requirements are met. The two big requirements to keep in mind are a finder's fee agreement has to be in writing, and the person that's the finder cannot do anything other than introduce you. They cannot negotiate. They cannot be involved in any of the other terms or conduct. They cannot perform any licensed activity. Okay. Where people get in trouble are they do not put it in writing and they let the finder, be the middle person through the negotiation. And what happens is the deal, what often happens is either the deal doesn't close and the finder still sues to get paid, or the deal closes, but the agent gets fired and another agent gets brought in and the deal closes, or somehow the agent gets cut out of the deal and the finder sues the broker anyway. And then, the broker's like, well, I didn't get paid, so I don't owe you anything. And the finder says, I did my job. The fact that you blew it isn't my fault. And then they sue and they end up in court, right? Or they file a DRE claim, right? So if you're going to use a finder, make sure you do it in writing and make sure you limit what the finder does. And then the last thing I want to talk about briefly is a lis pendens, because if I get one more call about somebody asking me to record a lis pendens so that I can stop a transaction for them, I swear I'm going to jump out my first floor window. Okay. A lis pendens is a Latin term for notice of pendency of action. Okay. What that means is, as a precondition to filing a notice of an action, is you have to have an action, right? Which is just a lawsuit. All a lis pendens is it's a notice of a lawsuit. You're recording for the world to know that a lawsuit has been filed. That's all it is. And you only record a lis pendens when your lawsuit claims an interest to title. Okay. So if I think I own a property or an interest in a property, I can record and I file a lawsuit, I can record a lis pendens. So what are examples of that? If I think if I think I own an interest, like if my brother and sister own a property and I was supposed to own a third of it and they cut me out of it, I can file a lawsuit and say they hold my 1/3 interest in constructive trust, and I can record a lis pendens. If I think I have the right to drive on her property because I have an easement, I can record a lis pendens. Okay. But most importantly, in the real estate context, if I am in contract to buy his property and he cancels my sale and I want to enforce it, I file a breach of contract claim for specific performance and I record a lis pendens that tells the world I have the right to buy his house. And it creates a cloud on title so that if she buys his house after I've recorded my lis pendens, she now is on notice that the judge may reverse her deed and give the property to me. Okay. For everybody listening, when a buyer cancels a sale and is in a deposit dispute, okay, that buyer is specifically saying, I do not want to buy your house. That is the exact opposite time of when you record a lis pendens, because you are specifically saying, I do not own an interest in your property. Okay, so you cannot record a lis pendens in a deposit dispute. And in fact, in a deposit dispute, you want the seller to sell the house for more money so that you can argue that the seller was not damaged and you should get your deposit back. So it is the opposite thing that you want to do. Okay. But for whatever reason, buyers get incredibly spiteful and they think that what they should do is kill the sale to anybody else until the seller gives them their money back. Okay. So that is it. You record a lis pendens when you think you have an ownership interest in title. You also, by the way, do not need to record a lis pendens when you are already an owner and on title. So with that, we spent a lot of time on the first two topics. We went very quickly through the last two topics. I got 12 minutes. I can answer questions on anything anybody wants.
Maybe. Again, phenomenal information here. Tony, let me ask you, let's get back to that finder fee. That's interesting that I've always understood that we're not allowed to give finder's fee unless they're licensed or if they're a current client of yours and you can go up to $500. I just got a newsletter from an agent. You just, blasted to everybody in the neighborhood offering $1,000 referral fee to anybody who turns them onto a deal. Therefore, I assume he's breaking the law at that point. Is that correct?
No.
Oh, he's not.
So it is interesting that the $500. So it's very interesting. The $500 comment comes from a National Association of Realtors memo that went national many years ago. It is not based on any law that anyone can find. And it is not based on California law, but it is cited over and over and over in treatises because NAR does a very good job lobbying because NAR doesn't want finder's fees, but California law has recognized them for 100 years. And there is no limit on them. There is actually a case from like the 1920s where the California courts upheld a finder's fee for 2/3 of the commission.
He's not breaking the law. I put that in there, $1,000 fee.
Not in and of itself.
Has to be in training.
Right. Now it may be unenforceable for other reasons as to what actually happens in the transaction, but in and of itself, paying a $1,000 finder's fee is not illegal.
You still have to write a contract.
You still have to write a contract, and the person's conduct has to be limited to nothing more than the introduction.
Let's say that there are two ranchers and they own this huge area of land. What if somebody's one rancher's cows and sheep encroach into other ranchers' land, and what can be done there?
That's a trespass.
All right, I got a question on Zoom. We're going to switch topics completely. If a tenant stays on the property, and if you don't want to answer this, it's good. If a tenant stays on property after close of escrow, can the buyer ask the seller to evict the tenant as well as sending a notice to the tenant that they are the new owner?
Say that again.
Okay, if a tenant stays on the property after the close of escrow, can the buyer ask the seller to evict the tenant? And can the buyer send a notice to the tenant that they are the new owner?
So the buyer can ask the seller to evict them, right? And the key in that question is ask. That you can ask the seller to do whatever you want. I mean, the seller's answer can be no. You bought the property with the tenant and you knew the tenant was there. It's up to you to evict them. The buyer can certainly then begin the eviction process and tell that, the buyer's going to have to tell the tenant I'm the new owner. The only caveat to that would be unless you contractually agreed that the seller was obligated to deliver the property vacant, or that the seller contractually agreed to handle the eviction.
Trust me, people put on Zoom, I can't hear.
Adding on to that, if when the buyer notifies the tenant that they are the new owner, at that point, can they raise their rent?
Raising rent is subject to rent control, or can be subject to rent control, and is subject to your lease. So just switching owners doesn't change the terms of your lease and doesn't change what rent control applies to.
So if they, at the end of, say their lease is coming up next month, if buyer notifies the tenant, are they subject to can they raise the rent more than, I think it's 5% for San Jose? because of the change in ownership?
The change of ownership doesn't give you any new rights that than previously existed. Right? When you buy an investment property, you're buying it subject to the lease that exists and the rights the tenants have.
Out of batteries.
It's okay. We're good. Thank you, guys. I appreciate it.